When you start a business in New Zealand, the law offers you a remarkable piece of armor. It's called limited liability. Think of it as an invisible barrier, a legal fiction that separates your personal savings from your company's risks, so everyday people can innovate without the fear of personal ruin. But that armor only holds up until the money runs out. Take the case of New Zealand Premium Trading Company Limited. After a disastrous dispute over exporting meat to China, the company was hit with a court judgment, ordering them to pay over $191,000. The company is completely broke. Its sole director, Andrew Parkinson, lost his entire business and has absolutely zero assets left. But he firmly believes the courts got it wrong, and he is desperate to appeal his case to the highest judges in the country. Here is the trap. The exact same legal structure that was designed to protect Parkinson from personal bankruptcy has suddenly mutated into a cage. In 2026, Parkinson brought his appeal to the highest tier of the justice system, the Supreme Court of New Zealand. He showed up ready to speak on behalf of his ruined company. The registry stopped him at the door. He was entirely barred from arguing his case. The rejection had nothing to do with the facts of the meat export dispute. He was silenced because, while he owns the company and made every decision for it, he was not a qualified legal professional. This creates a painful contradiction. The court requires a corporate entity to hire an expensive, independent lawyer to proceed. But how do you pay a legal team when your company has exactly $0 in the bank? To understand why Parkinson was turned away, we have to look at a rigid historical precedent from 1984, known as the rule in Re G J Mannix. Under the law, a company is an entirely separate entity from its human owner. Because of this separation, the courts dictate that a company can only interact with the justice system through a qualified third party, a licensed lawyer. This absolute strictness can be confusing because Parkinson was actually allowed to represent his company in the lower trial courts. Judges there made an exception to let him defend himself. But bringing a case to the Supreme Court is different. At the highest appellate level, dealing with highly complex procedural hurdles, that judicial leniency vanishes. The rule becomes a hard boundary. The Mannix rule functions as an ironclad toll booth. If a corporation cannot produce a lawyer, it cannot enter the court, no matter how right or wrong it might be about the actual dispute. There is a secondary reason the Supreme Court enforces this barrier. The system demands clinical objectivity, something that is nearly impossible to maintain when you are fighting for your own survival. The High Court had previously noted that Parkinson's devastation over losing his business severely compromised his testimony. His evidence was described as discursive, highly evasive, and heavily colored by distress. An independent lawyer acts as a filter against that emotional overload. Parkinson argued that his company is impecunious, meaning it has absolutely no money, and that denying him a voice is a denial of justice. The court's response was sharp. Being broke cuts both ways. If a broke, self-represented company is allowed to drag out a highly complex 6-year-old dispute, the opposing party is forced to spend thousands of dollars defending themselves. Because the company has no assets, the winner can never recover those legal costs. The ruling clearly prioritizes protecting innocent creditors and the efficiency of the legal system over one individual's desperate desire for closure. Zooming out to the wider commercial landscape of New Zealand, this ruling sends a very clear signal to the business community. The Supreme Court is acting as a clinical gatekeeper. It is establishing a hard, unyielding economic threshold for anyone trying to access the highest levels of commercial justice. If you are an individual human being, you have the right to walk into a courtroom and represent yourself for free. But a corporate entity is legally barred from doing the same. The reality is brutal. The moment a company goes bankrupt and can no longer afford professional legal fees, its practical ability to be heard in court effectively evaporates. For insolvent businesses, the doors to appellate justice are permanently locked. Unless they manage to secure highly unlikely external litigation funding or find a lawyer willing to work for free, their case is dead. All of this massive systemic deadlock stems from incredibly mundane origins, a commercial dispute over a few shipping containers of meat stuck at a port. Over 6 years, that dispute traveled from the industrial docks all the way to an ultimate procedural dead end at the Supreme Court. The corporate shield of limited liability is a brilliant tool for managing economic risk, but it is bought at a tremendous hidden cost. In the highest courts of Aotearoa, the ability to argue your case as a commercial entity isn't determined by who is right or wrong on the facts. It is strictly limited to those who can afford the price of admission.
Or will we stay silent, burying our meat? Or will we stay silent, burying